Hello, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Roberto Bornhausen. I'm a member of the local organizing committee from the University of São Paulo, and this is the second panel of our third day of the event. And now, I would like to present our sponsors, Jus Brasil, Albert Einstein Israeli Hospital, and also Urbano Vitalino Lawyers. Jus Brasil is currently the #1 law and government website worldwide that makes high-value legal information easy and quick to access. Albert Einstein Israeli Hospital, our other platinum sponsor, is one of the best-known health units in Brazil and Latin America. And Urbano Vitalino Lawyers is a law firm from Recife, Brazil. Now, we have 8 extended abstracts. We have here 8 participants to present their abstracts. And first, I would like to call to stage directly from Taiwan, Mrs. Huang. Please, Mrs. Huang, the stage is yours.
Thank you. So I'll share my screen with you. Just a moment. Okay, so hello everyone. Today I'm going to present our research on applying decision tree analysis to family court decisions regarding child custody in Taiwan. So I'm in charge of lab of legal analytics at the College of Law at National Taiwan University. And actually I'm a legal scholar, but I'm also interested in interdisciplinary studies, such as using statistics or computer science to studying legal issues. And as a law professor, our mission is to educate for future judges and lawyers. That is to say, the annotators that I will mention later are all our students who will become judges and lawyers in the future. And the third characteristics of our research is that we analyze legal text, basically written in Chinese characters. And also, because I'm okay, so actually, yeah, last year we participated in Colleague 2020, and in task 3 we got the first prize there, and this is a new attempt of our research. Okay, so I'll introduce the study today. So we will focus on child custody problem. This will arise after parents' divorce. And as we may know that if parents can agree on custody arrangements, then it will not go to the family court. However, if they can't, then the court will decide arrangement. The court judges will consider how to arrange in order to correspond to the best interest of the child. So the basic idea of this research is that we view court decisions as judges' behavior, and we explore their decisions in order to find out their preferences. And the second one is that through the studying a large amount of decisions, then we can find the law in action of the child custody. And the third part is that since Taiwan is a statutory law country, we do have articles regarding best interest of the child in our civil code. However, it is only a general principle. Then we don't know what factors do the judge consider important in individual case. So through this study, we can also figure out which factors that our judges emphasizes more. Okay, so here is our research design. We collected 835 cases involving 1,290 children. And we manually coded 19 features from the article of the civil code. As you may see in our civil code, it raises a lot of features that a judge should consider. Okay, so we built the model by ICAIL decision tree, and the model efficiency is 97% accuracy. I will show, because the time is limited, I will show the model demonstration. It shows that in Taiwan, a caregiver might be the first feature that's dividing the data. And then if the caregiver is the mother, that is represented by number 3, or both the mother and father are caregiver, that is represented by the number 2. Then next, child wishes will be considered by judges. That is the left branch of this picture. And then if the child prefers the mother or has no preferences, then there has a 95% possibility that finally the child custody goes to the mother. Okay, so this is the efficiency. I'll pass it. So I have only 1 minute left, so it goes to the conclusion. We found out that the primary caregiver, child wishes, and parent-child interaction are the 3 most significant factors contemplated by judges in Taiwan. And it turns out that machine learning technologies can be beneficial to empirical legal studies. And what we did is to manually labeling data instead of unstructured legal text data. And it performs better and gives a more explainable result to legal experts. Okay, so this study is funded by these organizations, and I hope that I will have future opportunities to collaborate with all of you. Thank you.
Thank you very much, Mrs. Wang, for your brilliant presentation. And now I'd like to call to stage right next Mr. Morris from Canada.
Hello, can you hear me okay, Roberto? Great. So I am presenting some work that I did as a member of the team at the Singapore Management University Center for Computational Law on using constraint answer set programming as a tool to improve legislative drafting. Rules as code, as we have heard from various people this conference, including Dr. Witt, is a proposal for modifying the way rules, laws, and other rules are written by involving programmers in the drafting process and co-drafting in both natural languages and knowledge representations at the same time. This is recommended as a way to simplify legal application development, to improve legal software quality assurance, and importantly, as a technique to potentially improve the quality of legislative drafting entirely. So the argument there is that avoidable drafting errors will be more likely to be noticed and fixed at the drafting phase by virtue of the attempt to formalize the draft law and the opportunity to test that formalization. So our experiment was designed to see if there's any evidence for this benefit to the quality of legislative drafting, and to see whether or not the programming language SCASP is an appropriate tool for that task. SCASP is briefly a stable model constraint answer set programming language. It is quite unique. Our main motivation for adopting it was that it features a combination of justifications and natural language generation, which were both very helpful, but as we discovered, those were only some of the very useful advantages that it has for legislative drafting tasks. The use of SCASP and our approach to defeasibility, which we borrowed from the Flora 2 programming language, allowed the encoding to be isomorphic to the legal text, by which I mean one section of the legal text corresponded to one section of code. Even when, as in this example, the legal text indicates that the rule contradicts 2 other rules, one of which defeats it and the other of which it defeats. Using this approach to the encoding of the other rules didn't need to change in order to write the encoding for this section and express those defeating relationships. So to simulate this rules as code drafting process, I, as the legal knowledge engineer, encoded a literal interpretation of Rule 34 of Singapore's legal professional responsibility rules in the SCASP programming language. I also encoded a set of tests separately that reflected my understanding of how the law was expected to behave. We ran those tests, which resulted in test failures. If those test failures couldn't be attributed to errors in the encoding, they were referred to a legal review team, who then looked to see whether there were errors in my interpretations. If they couldn't find an error in my interpretation, or one of them, then the legal review team analyzed the text of the original law to see whether or not the test failure was potentially being caused by a problem in the legislation itself. Our hypothesis was that drafting errors that were revealed by test failures in this way would provide evidence for the effectiveness of rules as code as a tool for improving legislative drafting. One such drafting error was discovered, despite the fact that we had no previous indication that it was there, and we were only encoding about 800 words of legislation. After writing 25 tests, 4 of them failed in ways that couldn't be explained by coding errors or incorrect interpretations. The specific problem we found was in Rule 34.1b. The legal review team could find no coherent literal interpretation of the requirement that a business materially interfere with a specific legal practitioner, given the abstract way in which the word business had been defined later in the rule. The team determined that it would be more reflective of the presumed legislative intent to say that an executive appointment materially interferes, not a business. So as might happen in a rules as code style drafting process, we proposed an amendment to the text. That amendment was encoded as an alternative, and when we ran the tests against that alternative encoding, all of the tests passed. So our experiment provides some evidence for the rules as code approach in finding problems in legislative drafting. We also learned that SCASP provides significant advantages to the legal knowledge engineering task, making it possible to get more information about the behavior of your encoding more easily. We also note that writing good SCASP code is still more difficult than it would ideally be to be able to give it as a tool to legal knowledge engineers who are maybe not experienced programmers. And we also have concerns about how well the abductive reasoning features may scale. The code for our experiment is open source and available at GitHub at the address indicated. My thanks to the members of the legal review team and to Professors Gupta and Arias for their teaching me how to use SCASP, and to our funders.
Thank you very much, Mr. Jason Morris. Brilliant presentation. Now, I would like to call to stage Mr. Nicolas Garneau from Canada as well.
Yes, thank you, Roberto. Can you see my screen and hear me well? Yes, all right. So good morning, everyone. Today I'll be presenting our extended abstract, Criminel Bart, which is a French-Canadian legal language model specialized in criminal law. So, well, the team behind this project is myself. I'm a PhD student in computer science in Quebec City at Laval University. And I've been working with Eve Gaumont, who is a master's student in the Faculty of Law. And I am also working with my supervisor, Luc Lamontagne, and the supervisor of Eve, Pierre-Luc Desiel. So I'll begin by introducing the underlying task that we are trying to solve. And it's a work that we presented at INLG 2020, the International Conference on Natural Language Generation. And in this paper, what we're trying to do, well, what we introduce is the task of bringing some intelligibility for the docket files, which we call the plumitifs here in Quebec. So the docket files are legal documents, semi-structured, that are at the core of a legal judicial case. So it's basically this this document right here on the left, and it has some references to the criminal code. We also have a bunch of, abbreviations sometimes and things like that. So this document is, in principle, accessible to the Quebec citizens, but it's barely understandable. So the goal of this project is to take this semi-structured document, extract the relevant information from it, and generate some kind of description out of it. So here we have that John Doe pleaded guilty of failing to comply with an order and committing mischief to property on January 1st on 2019. So this is the basic idea of this project. So the first model that we designed to generate these descriptions was a rule-based model. And it did have some problems on generalizing to other districts or to other domains. So we wanted to, hopefully we want to be able to train some statistical language models, such as the ones that we've seen. BART is one of the very good natural language generation models based on neural networks. And recently we've seen Barthez, which is a skilled pre-trained French sequence-to-sequence model. So our data set is actually in French. So this is why we started off with we want to start off with Barthez. But so what we did is we took around 10,000 legal judgments from the Superior Court of Canada, and we further pre-train Barthez on these documents in order to have a language model that have a semantic or somehow understanding of the criminal law and the lexical field and everything. So hence we have criminal BART. And so now there's nothing really new to pre-training the language model on specific data sets. But what's a little more interesting in this work is that we design a bunch of closed tests in order to see if the model grasped the semantic and the semantic features and the lexical field of the criminal law from Quebec City in Canada. So the first closed test that we design revolves around the criminal charges, where in this case we have the defendant is accused of something under the criminal code, and closed tests are exactly this kind of exams that a language model must pass. It must fill in the blank with one or several tokens, and so. From the results that we had, criminal BART was really grasp the distribution of the kind of accusations or charges that are comprising the data set. So at first, the model predicted driving under the influence, and then aggravated assault, possession of narcotics, dangerous driving, and hit and run. And so one of the reasons we chose to use BART for this task is that it's different from BERT, is that it's able to predict some spans of tokens. As we can see, it's able to predict literally this driving under the influence charge. So the other test that we designed for criminal BART is predicting legal provisions. So exactly the law from the Canadian Criminal Code. So for example, we have a given person is put on trial on charges of possession of cannabis, thus committing the criminal act provided in article something here. So we ask criminal BART to fill in this blank. And actually, the good answer is section 4 from the criminal code, but the ranking that we have was article 5, section 5, which is trafficking of substance, section 7, which is production, and then section 4, which is the possession of a substance. So what's interesting here is that we have many distractors within the law. For example, we have section 95, which is possession of illegal firearms, and section 163.13, which is possession of child pornography. So the interesting thing here is that criminal bar learned that there are some sections that are related to the possession or trafficking or production of a given substance, while these articles were not predicted at the top of the list. So the last close test that we designed was about privacy, because it's known that these kind of models may leak some data, and we know them as being stochastic parrots. So we want to know if we could retrieve, given a specific charge, fraud, or driving under the influence, or trafficking in substance. We want to know if we are able to retrieve a specific person. So from the result that we had, we were not able to really extract the identity of some person, but still, it could be concerning, because this model was only predicting the name of the most common person that was in the data set, which are judges, some lawyers. So it may be prejudicial to them if this model would be generating this kind of thing. But yeah, so this was an interesting close test to run. So to conclude real quick, we assess to some extent the capability of criminal law to establish some semantic relationship between certain provisions, which is kind of really interesting in the context or in the case where we would like to use it as a descriptor or generator of descriptions of criminal legal documents. So it's a really promising generator for diplomative descriptions that the task that we presented in 2020 and that we are actually trying to solve. So in our future work, well, we are presenting tonight another paper, which is Plume to Text, which is a data set, data to text data set for natural language generation. And we are looking into training or fine-tuning, in fact, this criminal BART model for the task of generating primitive description. So that's why we introduced this new data set. And this tonight we will be presenting how we created this data set, the different annotation tools and everything. So I'll be looking forward to see this presentation if it does interest you. So thank you everyone for listening, and I'll be up for questions.
Thank you, Mr. Nicolas, for your presentation. So you can join Gather Town for questions, as we don't have questions for this panel live. Okay.
Oh yeah.
Just to make sure.
All right. Thank you.
Perfect. And right next, I would like to call Wai Wing Mok from United States. Your microphone, please.
Okay. Yeah. Thank you. Let me share my screen. Okay, so this is a research effort. This is a research paper done by my son, who is a licensed lawyer in Birmingham. And I'm a professor at the University of Alabama in Huntsville. And my daughter, she's helping me to do some data analysis on this. In the papers, we introduce the importance of classifying different types of sentences in contract laws. And at this point in time, we are narrowing our focus on contract laws because, I mean, the scope is just way too big. I mean, the semantic is way too complicated. So we're trying to narrow down the scope to just focus on contract laws at this moment. Even that, I mean, the problem is already pretty big. So the way my son told me is during his first couple years, first year at law school, the way they do things is to classify the sentences. And then after that, they're trying to pick up the most important part of a court decisions. And then by generalizing those court decisions, we try to predict a new case, the outcome of a new case, and then try to find a similarity between a new case and those already in the database. I mean, trying to find the relevant legal precedents. So, so the 7 types of sentences we currently identify is the fact sentence, the court issue sentence, parties issue sentence, holding sentence, law sentence, procedural history, and references. Okay, everybody pretty much understand what a fact sentence is. It's essentially specifying the facts of the case. And then the court issue and party issues are the court issue is what the court considers to be the issue of the case. And then the party issue is what the individual party, I mean the plaintiff or the defendants, consider to be the issues. So, and then the holding sentence, in a way, this is the most important one. And this is the sentence that the court applying old precedents, and then what the court think is the central ideas of the case. I mean, it essentially is what the court think about the case. And then the law simply is just some reference sentence. And then procedural history is, of course, it's the procedural history of it. And then reference sentence, in a way, is the least important. It's essentially is just what those references. So the way we do it, we're using SPACY, natural language, NLP library to parse in it. And then we also we also build a database in order to do the match. So at this point in time, our database, our knowledge base is pretty small. We only have 12 cases. They're all drawing from Alabama, so the 12 of them. And then the first 5, we used it as training. So we identify the different sentences in it. And then the way we build the knowledge base is we extract the essential part of each sentence and put it into the knowledge base. And then when a new case comes, we use the similarity measure, which is based on the word vectors, and then compare with each sentence fragment in the knowledge base. And here's the result of our experiment. I mean, at this point in time, this is still very preliminary. And then considering this 7 sentence type, and this is what we got. Altogether, we have 1,063 sentences in the testing cases, and we got 646 sentences in the training cases. And then the accuracy at this point is about 69% for the testing cases. For the training cases, we got 92.41%. Now, this is not 100% for the training case because each time we enter some new sentences into the knowledge base, we somehow overwrite the old one. So it's just a tedious effect. I mean, each time we add something in it, we overwrite some old result, and this process is going to take a whole lot more time to adjust. So, and then we also maintain a 85% threshold for similarity. So if anything that is below the 85% threshold, we regard that as a fact sentence. It's just totally unique to the case itself. It doesn't have much, cannot do much about generalizing. So so that's the current result, what we have, and there's much more to do. And the next step, we probably need to look into the contract case more and to discover certain rules about the sentence structure in the contract case. That's the way we're going to. That's the way we're going to go after this tough problem. I mean, this especially the semantic is always tough to crack that. So that's the end of my presentation, and I thank you for your time.
Thank you very much, Mr. Mock. Right next, uh, straight from Canada, I'd like to call to stage Mr. Olivier Salon.
Hello. Let me get to my slides. Oh, geez. Wait a second. Oh, yeah, there it is. Can you see it? Okay, thanks. So good morning, everyone. So I'm presenting labels distribution matters in performance achieved in legal judgment prediction task. The authors are Olivier Salin, myself, Philippe Langlais, and Karim Benyakler from the University of Montreal in Canada. So first of all, I'm going to make a short introduction about what legal judgment prediction is. It's a task in which a model is given the description of the facts of a legal case, and the model is expected to predict the verdict that was originally decided by the judge. This type of task is usually formalized as a multi-label or multi-class text classification. One particularity of this type of task is the fact that decisions usually involve law articles can be used as additional input features. And one of our main goals in this work was to find out to what extent article-based features can improve classification performance. For this experiment, we used a corpus of decisions from the Tribunal Administratif du Logement du Québec. So it's a court in Quebec that is specialized in disputes between landlords and tenants. The decisions are in French, and most of the cases are related to issues such as late payment of rent or poor maintenance of the dwelling. In the first pre-processing step, we split each decision into two parts. So on one hand, we have the pre-verdict text, from which we extracted the description of the facts, and that will be used as text inputs. And we also extracted all the articles that were cited. So initially, we had more than 1,000 law articles, but we actually retained only those that were related to a housing law. So therefore, we retained around 445 articles from the Civil Code of Quebec. Concerning the verdict section, so this is a part that from which we will make our target labels. So with a mix of heuristics and domain knowledge, we managed to pseudo-automatically annotate our cases with 23 labels in order to cover as much as possible the diversity of the rulings. So for instance, we have labels for with one of the parties suffered monetary penalty, another label for eviction of a tenant, termination of the lease, or repossession of the dwelling by a landlord, for instance. Eventually, we removed from our data set all of the decisions for which we couldn't identify any verdict label, or from which we couldn't extract any meaningful housing law article. In terms of models, so we picked three. So our baseline is one versus rest logistic regression with a TF IDF vectors. Then we have a camera BERT model that is a variety of the BERT model, a pre-trained on French corpora. And finally, we used a combination of camera BERT with one-hot vectors that encode with some law articles or cited or not in the original decision. As a result, so we have the following table. So we notice that the inclusion of article-based features allow significant improvement with respect to a simple BERT model, both in terms of exact match and unweighted average of F1 scores. However, these scores alone hide the fact that the improvements are not uniform across all labels. If we look at the performance label per label, we notice that we have little to no improvement for the label with high frequencies. This suggests that articles have insignificant effect for labels that already have a high support. And also we noticed that the improvement are only significant for a handful of low frequency label. So as a future work, we intended to find out what the conditions must be fulfilled so that article-based features can allow better classification performance. So this is the end of this presentation. I would like to thank the Cyber Justice Laboratory, the Lexham Chair, and the ATC project for supporting this work. Thanks.
Thank you very much, Mr. Olivier. Right next, I would like to call to stage Mr. Antonino Rotolo from Italy.
Thank you very much. I share the screen. All right, thank you. Hello, everybody. This is a joint paper I prepared with, I worked on with Luciano Tamargo and Diego Martinez from Argentina. Has to do with two main issues. The fact that when we deal with artificial agents, and in particular with robots, legal norms and the interaction between artificial agents and norms is quite crucial. And one issue is how to handle the interaction between artificial agents, particular robots, with legal norms, insofar as we have to model norm dynamics, the law changes across time, and how to manage this when we have to deal with robots. The paper claims that existing models proposed, in particular within the IAAIL law community, can be employed in this case as well. There are a couple of preliminary research challenges that should be addressed. First, this first is preliminary. So the first is explain which of the following choices should be made in robotics. Nodes can be explicitly represented in a declarative way or can be represented in the overall system specification. The first case is quite good to handle legal dynamics, because insofar as norms can change, maintenance is very easy, but it's easier at least. The second option, maintenance in presence of norm change is more difficult, but we have an advantage, which is how to check that the robot complies with norms, and how to design a robot that complies with norms. Of course, in the second case, in the second option, when you have the overall system specification, you ensure compliance by design. So you adopt a method which is called regimentation in multi-agent system. But if you don't like regimentation, in a sense that norms are embedded in the system, then you are treating norms as soft constraints, and soft constraints means that you have a regulation approach. Norms can be violated. And then if you adopt the violation, this second perspective, soft constraints, norms are soft constraints, the question is how to check compliance if norms can be changed at runtime. So these are all research issues. This is an example I can give you. Suppose that this is an article over the Italian Criminal Code that says basically that if you induce someone to kill, to procure an offense, and this person is incapable, typically is incapable, then the fact that you induced this person to commit this crime leads to an increased penalty. But suppose now that Mr. Smith induces a robot to do something, to commit crime. Can we apply this article of the criminal code, Italian criminal code? Well, the answer is no, because this applies to persons, not to robots. But suppose that in 2005, this norm is revised in order to include, in addition to not incapable persons, also intelligent machines. So if you use a machine to commit an offense, you can get an increased penalty for that. Suppose that this is a change in legislation. Then the question is how the change is performed. You can have a change which is retroactive, typically annulment, or non-retroactive or retrospective, for example, abrogation. Retroactive means that if you annul a norm, it means that it's like if this norm were never enacted. While if you change, if you run abrogation, then you basically freeze the norm, but you don't remove from the legal system in the past. In the literature, there are many approaches. We discussed two approaches. They are here in the slide. And so I show you very shortly some pathway. I mean, suppose that you have the repository of norms. This norm can regulate the access, the robot behavior in terms of access control regarding the software dimension, but also regulations of violation regarding the interaction with humans. Then you have a static situation when you are in 2025, in 2005, then you apply the norm, the revised norm in 2005 in the two different dimensions, the access control and the regulation account, regulation. But then you have an abrogation in 2007. Then you don't have any problem at all in this perspective, because basically you have two different applications, two different compliance checks. One in 2005 and one in 2007. You have two different norms. You have a norm in 2005, which is a revised norm according to which machines are included, but then you have the abrogation in 2007, in which you no longer have this norm applicable, and then you apply the other norm. The difficult case, this is my last slide, is when you have the annulment in 2007, because the annulment is retroactive. So it means that from 2007 onwards, it is like if the norm was never enacted. So in this case, while the regulation approach, so soft constraint approach, is okay, this doesn't apply to the regimentation. How can you regiment retroactively? How can you design? How can you ensure the compliance by design in a retroactive way? So it means that regimentation is no longer possible if you have retrospective changes in legislation. And that's it. This is my last slide. Thank you very much for your attention.
Thank you very much, Mr. Antonino Rotolo, for your presentation. And now I would like to call to stage Mrs. Friederike Zufall from Germany.
Thank you very much. Can you see my slides? Okay, perfect. So this is a joint research project with my two collaborators from Japan, Nampe Kimura and Lin Yupeng. Our research is based on the legal concept of balancing of interest. So specifically, we have looked at the balancing decision between the right to the protection of personal data as stipulated by Article 8 of the EU Charter of Fundamental Rights against access to information as stipulated by Article 11 of the EU Charter of Fundamental Rights. This balancing decision is affected by what we call legal criteria. So, for example, the status of a person. So if we have information from a public figure, the balancing decision would turn towards access to information. While if we have information relating to a private person, and information on the private life of this person, the balancing would turn towards the protection of personal data. This is all based on the case law of the European Court of Justice. And additionally, as some of you might know, the court has stated the so-called right to be forgotten. So it has also introduced time as one of the criteria that can affect the balancing. The idea is that the balancing changes over time. The more the information lies in the past, the more the balancing turns towards privacy or protection of personal data. So what we did is simply we translated these legal criteria into mathematical legal parameters. We also defined the balancing's outcome, U, and used one single parameter to index U. So the idea is that the outcome can have a value between 0 and 1, and you can define a threshold, for example, at 0.5. When the outcome is then lower than 0.5, the balancing decision would turn towards privacy, while if it is higher than 0.5, it would turn towards access to information. This way, we can also model different legal systems that would set the threshold of this balancing at a different point. What we did then is we see this as a linear optimization problem. So we needed data that we could use to fit our function. The data was created by a fully qualified lawyer. And this is an example from our data set. So we used different points in time, alpha t, our parameter for time, as at 0 means that the information just occurred. Alpha t minus 1, it occurred 1 year in the past, and so on and so on. So we have different outcomes for different information throughout the passage of time. And this is also we also related to the legal criteria of the status of the person, alpha p, and the sphere of information, private or public, alpha s. What we then propose is what we call a time-independent mathematical model that takes alpha p and alpha s as input variables, and we fitted the data. This is the table of our fitted coefficients. And as you can see here, these are graphs that illustrate how the outcome of our function relates to our data. The data points are the dots, and the outcome function is the plane that you can see. Another step then that we did was to further develop this into a time-dependent mathematical model that also takes time, alpha t, as an input parameter. We then also used the same data that we created to fit this function. And what we achieved was, as you can see on these graphs, a continuous model for time. So you could use this function to model different points in time. And again, as you can see, the plane relates is the outcome, and the black dots are our data points. Our evaluation shows like the reduced chi-square, and we also did a leave one out cross-validation, shows that our model can represent the data sufficiently. Thank you very much for your interest. The full paper can be found on SSRN. I don't know if we have still time for questions. I try to keep it short. Thank you.
Thank you very much, Mrs. Frederick Zufall. Brilliant presentation. We have no time for questions in this panel, but you can go to Watertown right after and you can meet people there, or people can send you an email, okay?
Okay, thank you very much.
Perfect. So right next, our last presenter for this panel, Mr. Felipe Polo from Brazil.
So good morning. Can you see my screen, Roberto?
Yes, we can, but it would be better if you can, full screen.
Okay.
Perfect, perfect.
So good morning, everyone. I'm Felipe, and today I'm presenting a work I have written with Itamar and Emerson, and our work's title is Predicting Legal Proceedings Status Approaches Based on Sequential Text Data. So basically, our main objective here was to develop a predictive model to classify Brazilian legal proceedings in 3 possible classes of status. So a proceeding could be archived, active, or suspended. And this problem's resolution can help public and private institutions to handle large portfolios of legal proceedings, providing gains in scale and efficiency. in their operations. So let's talk about our data. So before we talk about the data sets themselves, we should say that each proceeding in our case is made up of a chronological sequence of short texts. So we are basically dealing with a sequence of text classification. And we have two data sets. The first one is a data set of around 3 million unlabeled texts that we use to train our unsupervised language models. And the second data set is a data set containing around 6,500 labeled legal proceedings, each with an individual and variable number of texts. And these data sets are sampled from the first and third biggest Brazilian state courts, São Paulo and Rio de Janeiro. So let's talk about our classification strategies now. Given that each proceeding has a variable number of texts, we should set a threshold. So we chose to work with the last 5 texts. And in order to classify the sequence of texts, we combined 4 feature structures with 3 classification architectures. By feature structures, we mean language models. And they are Word2Vec, Doc2Vec, TF-IDF, and a Brazilian Portuguese BERT-based model. As classifiers, we used multi-layer perceptrons, LSTM neural nets, and an XGBoost classifier. And while LSTM can naturally exploit the temporal structure of the sequence of texts, and when using the multi-layer perceptrons and the XGBoost classifier, we had to concatenate the last 5 text representations to have a unique, unique vector of features for each sequence of texts. And here we have our basic results, classification results. As you can see, the best results we got when using the combination of LSTM with Word2Vec, using a convolutional layer to extract features from each text, and LSTM and BERT. So now that we have talked about the classification itself, it's interesting to talk about interpretability, how we use our models to make interpretable insights. And when using the LSTM combined with the Word2Vec representation, we're actually using a convolutional layer to extract features from each of the texts. So we have the LSTM, CNN, dash Word2Vec architecture. And using this architecture is very convenient for us because we can, after training our model, we can interpret the convolutional filters, comparing their final configuration with tokens in our vocabulary. So we can see what kind of patterns the neural network is searching in our texts. So basically, we take a look at the embeddings representations of tokens closest to representations of 3 out of 9 filters. For example, here we have filter 6. So it says when you can see that it says that when a proceeding is going to be archived or is archived. Filter 7 is related to the archived and suspended classes, while the filter 8 doesn't seem to be related with any of the classes at all. And we can confirm our intuitions looking at this plot here. So for example, these are partial dependence plots. And looking here, for example, in filter 8, you can see we have basically flat plots. That means that filter 8 doesn't have a relationship with any one of the 3 classes, while filter 6 and 7 have a very strong relation with the outputs model for class 1, 2, and 3. So this was our work. The full version can be found on archive. And here are contacts. So thank you very much.
Thank you very much, Felipe, representing Brazil and our university. Very nice to have you here. And well, so this was the last abstract paper presented. And now, just before we finish, we will have a break for 1 hour and 20 minutes. and we'll be joining GatherTown. So once again, I invite you all to join GatherTown with us, and we'll be chatting there and talking about the papers and having a nice time. I'll present here again my screen. So I'll show you how to join GatherTown. So first, you have to be at the conference OpenFi platform, and then 1 second. And then here inside the platform, you have this left part of the platform where you click the star, GatherTown. Then you click join, and you join with your browser. There's no problem, or the platform if you downloaded it. And then you have here this space where you can see my screen, and you can join the gathering, and there will be people there waiting for you, and you can have a good time and talk with them. Okay, so thank you very much for everyone who's watching, and see you there in GatherTown and then in the next panel. Bye.